Miss Carrie Marty and Brian Zeller are, my understanding, former neighbors. While they were neighbors between December 2nd, 2024 through December 2nd, 2025, there was a civil protection order in place in which Miss Marty was the protected party and Mr. Zeller the respondent. I know there was some allegations in the current petition around, possible behavior during that time, but there was no violation of the order as far as I can see during that period of time. December 12th, 2025, so soon after the order had expired, Mr. Zeller placed a letter in Miss Marty's mailbox that appears intended to apologize and try to offer some context and want to build a relationship moving forward or things of that nature. A few days later, December 18th, 2025, Miss Marty responded also in writing, indicating that she maybe, while appreciated where he was coming from, didn't want any further contact. Then January 13th, Mr. Zeller, I believe it's indisputed, but left a note on Miss Marty's doorstep or around her property saying something to the effect of all it would have taken is being nice. Miss Marty interpreted that in sort of a threatening way. Mr. Zeller has denied that there was any threatening intent behind that. Fast forward to May, Miss Marty claims that Mr. Zeller had some words with her daughter. Mr. Zeller indicates that doesn't recall that. And then on May 6th, there's an argument between the two. The nature of that argument is very different depending on which side sort of tells it. But there was some sort of argument between the two, leading to Miss Marty contacting law enforcement. And then since then, my understanding is Mr. Zeller has left and is no longer neighbors with Miss Marty. But nonetheless, the petition was filed and here we are. So that's my review of the record. So again, I'll give parties a chance on both sides to, again, fill in the gaps, correct me where I'm wrong, provide extra context, that sort of thing. But I think it's helpful to know where I'm coming from. So to begin then, we'll start with the petitioner. It is Miss Marty's burden. So Carrie Marty, if you could please raise your right hand. Do you swear or affirm that the testimony you're about to provide on this matter is the truth and the whole truth?
Yes,
okay,
I do.
Go right ahead.
All right. I did move here back in 2023. I moved from Snohomish to be by my sister. She had moved here the year before. I met Brian and exchanged numbers just for in case of emergency and just overall neighborhood watch. After a few months, he began showing signs of unstable behavior and would often lash out via text out of nowhere and out of context, completely initiating contact. In the beginning, I would ask him if these messages weren't meant for someone else because it didn't make any sense to me as to why he was sending them. He would later apologize profusely, telling me he was dealing with stuff and he was so sorry. I began to avoid him because I didn't want to trigger any of these outbursts. This came to a head when he began involving my daughter in his rants and accusations. And at that point, I had requested the anti-harassment. Fast forward to the current, respondent had, he did drop off the letter in my mailbox. He signed off by saying, if you're not capable to forgive and he would understand. And if that is what I wish, he wishes me the very best. I did respectfully decline in writing, saying I would prefer we continue the no contact the same as the past year. This was mainly because I didn't know what was triggering him and I didn't want to go through it again for both of our sakes. It was extremely unnerving for my daughter and myself in a new town. I signed off on that letter. Continue to get better. I wish you well. This is where it should have ended. We should have nothing else should have happened after that. January 13th, he did leave a note on my front porch. It's not exactly close. He would have to walk quite a distance to get there. I did send him a letter. I did tell him I had been nice. I literally just wanted to be left alone. I signed it. Please just leave me alone. On the 2nd, he did approach my daughter while she was getting the mail. She can talk through that when it's her turn. It did frighten her, startled her. She did return to the house quickly. On the 5th, the respondent's landlord came to my house and asked for clarification regarding an allegation made by the respondent. Both my daughter and I provided statements. Before he left, he warned us he was going to be terminating his lease and that the next few weeks were going to be tense. On the 6th, I was moving storage containers from my garage to my shop so I could work on a leak I noticed over the winter. I noticed there were a dozen new molehills in the yard. I grabbed the deterrent. I was bent over at the first molehill when he came out of his house towards me, started yelling excessive profanity and name calling. He was screaming that I had ruined his life and I had harassed him for a year and a half. I yelled back to please leave me alone, that I hadn't looked at him or in his vicinity, nor had talked to him about him. I just wanted to be left alone. At this point, there were people at Subway watching as he continued to yell at me, stating the whole town had been following him. I told him I only knew my sister and her daughter's family, and he said that was BS. He went on to say I was being investigated by the police and I had no idea what was coming for me. Just wait. Knowing this was escalating and I wasn't getting anywhere, I just yelled back, fine, I'll call the police so they can work this out. He continued to yell at me until he realized I was on the phone with a non-emergency operator. He ran into his house, ran back out, got in his car, and peeled out shooting rocks. I did end up speaking with the officer and decided to resubmit for another anti-harassment order. The declarations that were made regarding his sister's declarations, both of those are solely based on individual conversations and not witnessed facts. I know the respondent has extreme anxiety. He has told me that. He has a hard time in the past with his perceptions, and I've personally witnessed it and documented it in the first protection order. Regarding his declaration, there's things I feel necessary to address. His statement regarding how we initially met and our interactions thereafter are grossly misstated. From day one, I was kind and accepting to what he was going through because my youngest daughter was going through similar struggles, and this was confirmed as he admitted in his handwritten letter. The reason I care so much is because you guys were nice to me when it mattered most. This is a very big deal. If there's anything I can do to make up for how I acted, I would gladly be willing to do so. His statement regarding my daughter's boyfriend revving his car at all hours of the day and night for 8 months is completely inaccurate. My daughter's boyfriend stayed with us just short of 6 months, and 4 of those months, his car sat inoperable in the grass by my shop. On February 19th, they broke up and he hasn't returned since. His claim of my daughter yelling from the highway and from a truck doing burnouts and driving past his house is preposterous. My daughter has intentionally avoided him at all costs, including not going outside if he's outside. As you can see from the Google map image I provided, how far away the highway is from his house, where the subway is, and the abrupt dead end blocking with the pole yard on the other side. I have had few family members and friends visit from Snohomish, 4 at the very most, and it was my kids. No one we know owns a truck. I've never witnessed any or seen burnout marks in my road between our houses. And then lastly, I just want to address the claim that I was the reason he was evicted. I did submit a statement from his previous landlord discrediting that claim. In turn, I could have had my sister submit a declaration as she's personally witnessed this behavior, but I did not want it to turn into a tit for tat or he said, she said. I'm not here to place judgment or attack his character. I am fully aware that he has since moved to Westport as he outlined in his statement. However, his mother resides in Chehalis and he has family all around the area. Given we live in a cluster of small towns with most retailers found in Centralia, Chehalis, there's a significant probability that we could be at the same retailer, restaurant, or area at the same time. Given his history, I'm not sure he could refrain from lashing out or making a scene if he saw me or my family in public. That's all, Your Honor.
All right, thank you, Ms. Marty. All right, and all right, when it comes to non-parties, and so now, and this is this Madison. Oh, I guess it's labeled there. Madison Marty's at you, ma'am.
Yes, it is.
All right, so non-parties typically are not allowed to testify unless the court finds their testimony would be necessary and material for making a decision. In Madison Marty's case, while she's not necessarily the petitioner, she is listed as a protected party in the petition, and some of the allegations and the response to those allegations do involve interactions exclusive with Madison Marty. If there's anything, you don't have to testify, Madison Marty. If there's anything though that you would like to add as far as the allegations from May 2nd or any of the others, you're welcome to testify as well. And if so, I'd put you under oath first, but is there anything, I just asked first, is there anything you would like to tell me?
Yes, Your Honor.
Okay.
Just a quick one from May 2nd.
All right, if you please raise your right hand. Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
I do.
Okay, go ahead.
May 2nd, it was about 10 a.m. and I had just woken up. I noticed that I had got a notification that I had a package delivered, which I did not after going out to the mailbox, but I didn't know that. I walked outside in my pajamas, unknowing that Brian was outside. I didn't have my glasses on, so I was squinting. I couldn't exactly see. When I went outside, I turned my back. I could hear him yelling across the yard from behind me. He wasn't standing in the driveway. He was standing in his yard, but facing me and directly talking to me. I don't exactly know what he said in the first part. I know in the second part, he said, "You guys just need to be nice," but in a very angry tone, I would say. I said, "Okay." He just kept saying it. I said, "Look, I'm sorry. Have a nice day." And I got back inside as quick as I could. I told my mom what happened. And that is all I have from that day.
Okay. Thank you.
Yes.
Are you able to describe how that made you feel?
Shaken up just a little bit. I do have a problem with like confrontational anxiety. So when I do get confronted or yelled at or things like that, my body does tend to my heart rate just spikes. My body goes numb a little bit. It's kind of like an adrenaline rush, but in opposite effect. So I was definitely shaken up a little bit. My heart was racing when I walked inside, and I couldn't feel my legs.
All right. Thank you, Carrie and Madison Marty, for your testimony. Next, I'm going to hear from the respondent and the respondent counsel. Ms. Cruz, would you like to go first? Would you like your client to testify? I'll sort of let you direct the ship on your end.
Yeah, Your Honor, I have some questions for my client.
Sure. All right. Then let's see, Mr. Zeller. Did we lose Mr. Zeller?
If we did lose him, he did let me know that he doesn't. Oh, he's getting back. He's getting back on. He got kicked off really quick.
All right. We'll hold off for Mr. Zeller.
And then I would like to reserve a closing.
Sure. All right, Mr. Zeller, looks like we lost you there for a minute, but now you're back. Are you, can you hear us okay? There we go. Nope, no problem. All right, Mr. Zeller, I'm going to put you under oath now, and you'll take some questions from your attorney, and I may have some follow-up as well. If you could please raise your right hand. Do you swear or affirm the testimony you're about to provide today is the truth and the whole truth?
Yes.
All right. Go ahead, Ms. Cruz and Mr. Zeller.
Thank you. Mr. Zeller, tell us what was the intended purpose of that initial note that you had left in their mailbox?
I just wanted to apologize for them dealing with my anxiety, and I wanted just to move forward in a more positive and friendly manner.
Okay, and tell the court, just in case it might become an issue today, do you suffer from extreme anxiety?
Yes, I do.
Okay, does it sometimes get to a point where it's debilitating?
Yes.
Okay. Um, any notes that you've ever left or any letters that you've ever left to the petitioner, were any done in a threatening manner?
No.
Okay. And tell me about the day where, well, let me first say, do you remember or do you recall a day where you were speaking to their daughter on May 2nd?
No.
Okay. And tell me about the verbal disagreement that was outside. Tell me about that day.
Anything specific?
Just tell me how kind of that it started.
I was just going to my mailbox. I just woke up. I was groggy, and I came out and was walking to my mailbox, and she was digging in a mole hole, and she just pokes her head up and like giggles and tells me she got me evicted, and um, and then from there, I uh, said that she had issues, um, and then I asked her to stop having her friends harass me and going by my house, and uh, I she then said that she claimed that she didn't have any friends, and I then said that's BS, and I went inside and I went over to my she ran over and sat on her porch and called the police on me. So I went inside to grab my keys and left and went into my friend's house to get away from them.
Okay. Did you perceive the petitioner at that time as afraid of you?
No, she also stated that she's told me to come fight her.
Okay. And so is it your testimony who started the discussion?
She did.
She did. Okay. And Mr. Zeller, when did you move approximately?
Gosh, I think it was about a month and a half ago.
Okay. And where did you move to?
I stayed in cabins in Ocean Shores to get away, and then I uh, went to my original hometown, Westport, and I've been here since.
Okay. Approximately how far of a drive is the city of Westport to Rochester?
About an hour and a half.
Okay. Do you, the petitioner states that you have family in Rochester. Tell the court, are you close with those family members? Do you visit them or not so much?
Um, the ones that are in Rochester, I don't really talk too much, and they visit me anyways. And my parents actually live farther south, so I don't really see any reason for me to even run into them.
Okay. Do you have any desire to go back to your former residence or even Rochester at all?
No.
Okay. Um, did you, when you moved, did you have any belongings at your home that were left?
Yeah, I actually left some of my belongings because I was so uncomfortable. I didn't even want to be there. And I called my landlord's son and asked if he would meet me there so then I would have someone there just in case anything happens. And he said he wasn't able to, so I declined to even stop there because I was just too uncomfortable to be there by myself.
Okay. And the petitioner alleges in her petition that despite you moving, she's afraid that you'll return to harm her, her daughter, her dog, or damage her property. Mr. Zeller, have you ever hurt her, her daughter, or her dog?
No,
Have you ever damaged their property?
no,
Do you have any reason to have any further contact with the petitioners?
No.
Okay, Your Honor, those are all of the questions that I have. Thank you.
Thank you, Ms. Cruz. All right, Mr. Zeller, I have just a couple of follow-up questions of my own. And they are specifically around the May 6th incident, because that's where I think yours and the petitioner's kind of allegations seem to diverge more than anywhere else. And so in the petitioner's exhibit materials, she describes the May 6th incident as, let's see. I got to zoom up on it. Sorry. She claims that during the course of that argument, that you said something to the effect of, you have no idea what's coming for you. Do you recall making that statement or something similar to that?
No, I never said anything like that.
Can you think of anything you may have said that could be sort of interpreted as something to that effect from that that incident?
No.
And it was your testimony, if I remember correctly, that you were walking to your mailbox and that Miss Marty initiated the contact that led to that argument. Is that right?
Yes, Your Honor.
Okay. All right. Those are all my questions, Mr. Zeller. Thank you. Yeah, I know Ms. Cruz requested some time at the end to make a closing statement. And that's fine. I'll have my final kind of engagement here is I have a few rebuttal kind of questions for Carrie Marty. And again, this is trying to suss out a bit more this May 6th incident. And so we've got Mr. Zeller testifying that his understanding was that you initiated the contact. I know from your description of May 6th that you believe he initiated the contact. Can you talk more about how that engagement started?
Yeah, sorry, I'm frustrated. I was bent over and I'm like putting deterrent in the hill, like in the molehill. And he starts yelling. He's outside, he's yelling, and he's like something to the effect of, I've ruined his life and for a year and a half. And then I looked up and he is, the only thing I can say is spewing. It was like this, almost a minute long repetitive statement as if it had been rehearsed, and he's just going off on me and screaming, and I've ruined his life. And I'm like, I kept saying, just stop, just leave me alone. Nobody's talking to you. I know he claims I have all these friends. I don't have friends here. It was very uncomfortable. It makes it's unfortunate because I'm sure he is a nice guy, but if you look at this entirety in this pattern, you can see that he is not only tormented me, but some of the things that he has said in text messages are just bizarre and unnerving. I have called the police multiple times because it does freak me out when he starts getting like that. So when he said, just you wait, I was shaking so bad. I'm like, that's fine. Let me call the cops right now and let's get this figured out, because I can't do this.
All right. Okay. Thank you. And I asked him about this statement. So I'll ask you too. I know, again, I have your exhibit here in front of me. So your recollection is that he said during the course of this, you have no idea what's coming to you. Is that what you? Okay.
Yeah, he said I was being investigated and that I have no idea what's coming to me. Just wait. That's when I panicked, and I was like, that's fine. I'll call the cops right now and let's just get this figured out. And he's still yelling at me, and there's people in Subway staring at us. In the moment, I wish I had just gone to get a statement, and I didn't, but I did call non-emergency line.
Okay. All right. Thank you, Miss Marty. I'm going to hear from Ms. Cruz next. She'll have some concluding remarks to make there. I don't have any more specific questions for you. Is there anything you'd like to say to sort of summarize your petition or any concluding remarks?
Is that from me, Your Honor?
Yes.
One thing I just want to say is I didn't want to bring any of the previous tenants, relationship with their landlord up, but he had a moving company provided by his landlord and they cleaned his house out. So like, I'm not trying to do this out of any, I live in a very small town and there's a grocery store here that's expensive. So I'd have to go to either Walmart or even if I need anything for my house, Home Depot. That's all in Chehalis. There's very few large box stores here and I have to go down south to do any shopping. So I'm not sure how I want to end that statement and I'm flustered.
All right, understood, ma'am. And thank you. That's fine. And again, I do have your petition in front of me with your statement. All right, Ms. Cruz, I'll turn back to you for concluding remarks.
Thank you, Your Honor. A few different things here. First, really, when you look at the situation as a whole, I'm going to argue that there's no course of conduct. So we do have a prior protection order. I understand that. However, here, the next thing that we have for this protection order, the first thing we have is a letter that did not in itself alarm, annoy, harass, or was not detrimental to the petitioner. She has not testified to that letter in itself has completely just bothered her. And then we have the petitioner sending back a return letter. She actually even sat on that first letter, not sure what to respond for a while. She said it took her a little bit of time to think about, but that letter in itself wasn't detrimental. And then we have where a situation where the petitioner is saying that my client spoke to her daughter. My client doesn't actually remember that day. And to be honest and fair, Your Honor, the petitioner's daughter testified that she couldn't see my client, nor she could barely hear if it was my client. So it's not even completely known what was said, nor if it was him. He doesn't recall that specific contact with the daughter in itself. And then we have an alleged note in a door here. I think that it could be annoying possibly at this point. This is where I think we have the one conduct, but course of conduct has to be two or more separate continuing acts or contacts. So I think the note in the door potentially could be. However, what was specifically stated in that note, I don't see how it could be very detrimental to somebody's mental health. There's no threat, there's no anything like that. More of anything like, okay, that was a weird thing to say. Lastly, we have a verbal dispute outside. There is some different renditions of this depending on who you speak to, but my client is testifying today that she spoke to him first. Additionally, although the petitioner is not required to, she has heard multiple times now that my client has said that she has threatened, hey, come fight me then, and she hasn't actually denied that she said that. So my first argument is that there's no course of conduct. My second argument is that there is some testimony to emotional distress. There's not enough testimony as to substantial emotional distress. Some annoyance, or like I said, even some emotional distress is not enough under the RCW. It must be substantial. The daughter even testified after an encounter where she could barely see or hear a person. I wrote, she specifically stated, I was shaken up, quote, just a little bit. Surely not substantial emotional distress. And my last argument is, although it's not required to prove under the statute, I still think this does matter. My client moved away. He moved very far away. In fact, he moved an hour and a half away. Even if he were to come visit family and, let's say, accidentally run into the petitioner at Walmart or what have you, if a protection order was put in place, that's not going to prevent accidental run-ins. What it can prevent is somebody speaking to one another, but it's surely not going to prevent an accidental run-in. However, despite that, my client has no intention to return to his former neighborhood at all. The petitioner states she is afraid that my client will come back to Rochester. That's a fear. There's no proof of that. Lastly, the petitioner states that she is afraid he will mess with her house, car, daughter, or dog. There's no proof of any of that happening. He has not physically harmed anybody, and he has never, you know, come and destroyed their property, for example. So at that point, we have a fear that he is going to return. But Your Honor, that's not at all what my client is testifying that he wants to do. So I think that it matters. And, you know, he didn't move 20 minutes away. I think it would be out, you know, he would have to travel an hour and a half to come harass these people and then leave. I don't think my client has any intention of doing that, and he testified today that he doesn't. He just is trying to move on with his life. So, Your Honor, based off of the no course of conduct or no course of conduct or a lack thereof, and then not enough testimony to establish substantial emotional distress, and the fact that my client has moved away, we're asking to find in my client's favor and find that the petitioners did not meet their burden. Thank you.
All right. Thank you, Ms. Cruz. All right. I'm going to just take a minute or two and finish up reading a few of the materials here from both sides before I make my decision.
And Your Honor, I apologize. I would like to make one objection. I was sent an email that was provided, it looks like, from my client's former landlord. Your Honor, I understand that there's very relaxed rules in these hearings and that pretty much anything goes. However, it's not at all provided under penalty of perjury, and I always think that matters. So I'm going to argue that the last thing that was submitted should not be considered. Thank you.
All right, thank you. And I don't actually know if I even had a chance to review. There's an email from the former landlord. Is that what I'm hearing?
I don't know. I was sent, well, petitioner tried to serve me with the document. It wasn't attached to the email. I let her know it wasn't attached to the email. So she forwarded me an email that was from the former landlord. So I don't know how you're looking at it, but I know she's shaking her head. Can I ask the petitioner? She's been shaking her head the whole hearing. Please stop. Thanks.
All right. Well, so here, hang on. I haven't had a chance to review what has been filed on, looks like that was what, Thursday? Part of it too is, there's, once cases are filed, the notice rules, apply to when somebody is served before a hearing to give parties a chance to hear everything.
Your Honor.
Thursday before the hearing, is that Thursday? Yeah, okay. We do try to, again, the rules, as Ms. Cruz there noted, are relatively lax. But when it comes to the rules of evidence, which don't apply, okay, go ahead, Miss Marty, if you'd like to say a few words here, but I'm just looking at this now. Go ahead.
Your Honor, the declarations were shared with me 5 business days prior to today. I was first of all, I wanted to address, I didn't address everything that was in those declarations, but I wanted to address the one where he's blaming me for him getting evicted. So
Yeah,
I
so
called the court.
but hang on, Miss Marty. So there's a couple of things that I want to just kind of focus in on. The first is, so I've got looks like Mr. Weaver submitted information about kind of the issues with tenancy. I'm not considering on one side or the other, you know, Mr. Zeller's kind of what happened for him as between him and the landlord and what led to an eviction. I'm not considering that. I'm looking at Mr. Weaver's email. I don't really find this relevant. And then on the same time, I'm not, you know, the arguments that you know, Miss Marty got him evicted as well, I'm not considering as a response either. So this evidence around and the arguments around, you know, Mr. Zeller being evicted and who got him evicted and the landlord's perception of him as a tenant, I'm not considering any of that as part of my decision today. And so I think that is a separate issue that I'm not considering one way or another. What I do though think is relevant, and I know I kind of already noted that Miss Marty had said her final piece here, but I do have one last follow-up question. Miss Marty, do please try to keep your comments confined to answering this question. Ms. Cruz did raise as one of her arguments testimony around the elements on substantial emotional distress. That is a question in my mind as well. I know that's something that you didn't really expressly hit on one way or another. As the finder of fact in these hearings, I'm able to observe witnesses. And while you're on Zoom, you know, it's my observation that you seem, in my opinion, rather distraught. As a, you know, again, the finder of fact here, one of my roles is to assess witness credibility and how witness presentation. But at the same time, I think Ms. Cruz does make some good points. I do want to give you, though, the opportunity, since it's your burden, to address that particular argument on even taking all of these things as true, whether or not that led to substantial emotional distress. I'll give you an opportunity to address that argument, though.
I wish sorry. The amount of distress that this has caused me is unmeasurable. I've gone to the doctor multiple times. I shut the curtains in the front of my house. I hide in my house because it faces that side. Only in the last month have things really started to calm down, and I feel like I'm getting my peace back. But no, everything that he does and says, it literally rings like panic, sheer panic. So yeah, he said not to bring anything up, and that's fine. I don't know how else I can say it. I'm trying to be respectful. I just want him to leave me alone.
All right. Okay. Thank you, Miss Marty. So this time I'm prepared to rule. And for the record, I didn't consider arguments on either side regarding Mr. Zeller's status as a tenant or the eviction and reasons behind it in evictions and things of that nature. I agree with Ms. Cruz that isn't necessarily relevant to these particular proceedings. That said, I am finding in favor of the petitioner, and I'm going to go through why. And I'm going to start with the no course of conduct argument that was raised by Ms. Cruz. And I think it's important to address. It's also the first element. And as I said at the beginning, Ms. Cruz is correct that a knowing and willful course of conduct is that very first element here. And I do find, though, that it's more likely than not that a course of conduct exists. While the original civil protection order had expired when the current allegations began, I do think the status of that order is relevant for determining not whether there was a violation of a court order, which there wasn't, but whether there is an ongoing course of conduct. And I think the that the first civil protection order expired on December 2nd, and then on December 12th, Mr. Zeller, sort of which is not in dispute, puts a letter in Miss Marty's mailbox. I think that does show that he was ready to engage with the Martys as soon as that order expired. If it had stopped there, I don't think there would have been an issue. Miss Marty, as she indicated, kind of sat on that for a few days and considered it. I think she was upfront in her response, even that she took some time to think about what he said and whether or not to allow continued contact, but did then reply and pretty unequivocally saying, essentially, I wish you the best, but I would not like any further conduct. Again, at that point, I think everything is fine. I don't think there's been any unlawful harassment at that point. What concerns me, though, is then about a little less than a month later, is then there's another note from Mr. Zeller to Miss Marty on her doorstep saying, all it would have taken is being nice. Even if that wasn't intended as a threat, which I'm also, observing, Mr. Zeller, it seems in the context of the nature of his first note and then this one, I can see a world in which there was no real harassing intent behind that. But that does come within the context of pretty unequivocal response from the Martys saying, go on any further conduct. And then there are allegations after that of further engagement. I realize engagement when there's neighbors, that can be difficult to avoid. But I think looking at this as a whole, stepping back and looking at the greater context here, we've got a civil protection order expiring a couple days later. We've got a written note, a response saying we don't want any contact, but additional written communication after that. And then two, at least one disputed, but an allegation of contact, and then undisputed contact between the two. So I think looking at that in the context of this first protection order having just expired, I do find that there's that course of conduct. I also find that there's evidence of both subjective and reasonable substantial emotional distress. Again, as the finder of fact, one of my jobs is to assess witness credibility. And I think it was outlined in the written materials. Miss Marty had expressed in her written materials, feeling distressed. I take her testimony today as substantial emotional distress. And I also think looking at the substance of the communication, again, that first note being sort of apologetic in nature, I think that coming on the heels so soon after the first order expires and then follow up in written engagement, I do think that would, again, looking in the greater context, would cause substantial emotional distress. And the last thing I'll say on that too is, I think the first letter from Mr. Zeller was on balance sort of kind-hearted and understanding, Mr. Zeller, your the anxiety that you suffer, and I don't dispute that at all. It seems like you really do. And so the on balance, the note does seem to be sort of good-natured. But another thing that sort of does concern me is at the end at your postscript, you do say that I'm genuinely trying to do the right thing, so please don't get freaked out or try to get me in trouble. What that tells me is, even in that first note, there was a sense that this might not be okay, and this might not be acceptable for me to have done this. And I think that's clear in the PS that already there's that sort of.
Am I able to respond to that?
Well, I've made my decision, Mr. Zeller. And so, at this point, again, on balance, I think you were reaching out to try to, mend fences. I'm not saying there's anything ill-natured there, but I think the ongoing communication after that pretty unequivocal response from Carrie, Marty, that's really what I'm kind of grounding my decision on. And then the final piece about, it sounds like you live in Westport. And you're not neighbors anymore. That is important in these decisions. But that said, this is, that doesn't necessarily categorically mean that, a no protection order is no longer appropriate, especially when we are in a relatively small community here in the South Sound area. So I don't think someone moving from Rochester to Westport necessarily addresses some of the concerns about ongoing contact in this situation. So I am granting the order. It will continue for another year. The provisions of the order will include and folks will get copies of these, but they will include no contact with both the Martys, Carrie Marty and Madison Marty, directly or as it shows in the order through third parties or electronically. As well as a let's see. Yeah, and then there'll also be the exclude or stay away order. Now, I understand that, Mr. Zeller, you live in Westport now, so hopefully the exclusion from Miss Marty's property is not going to be a problem there. If you all do run into each other incidentally, as the language of the order indicates, it's not coming within or knowingly remain within 1,000 feet. So what that means is it allows for that kind of incidental contact, provided there's no communication. You just got to extricate yourself from the situation. So if you run into each other at the store, it's knowingly remaining after knowing you're within that buffer, and then knowingly remaining. That's the violation there. So it does allow and recognize for that incidental contact. So those will be the two restraint provisions of the order. Like I said, I'll be signing those today. Mr. Zeller, I'm going to ask you if you have any questions. I'm making my decision now, but do you have any questions, sir?
I'm just wondering, if they were to continue to harass me, well,
I can't give you legal advice. What I'll say is nothing prevents you from going through the same process as a petitioner.
I was told that's retaliation. I actually wanted to do that myself, but I was scared to because it looking like retaliation.
Well, talk to an attorney. It sounds like you've got Miss Cruz in her firm. So if you have legal questions, I'd direct you to your attorney.
Okay.
But you being the restrained party in a protection order doesn't prohibit you from engaging in the same process. So talk to your attorney. Any other questions, sir?
No.
And to the Martys, any questions?
No, Your Honor.
All right. I'll be signing that order later today, and then do we send out?
It's just the electronic case file.
It's just an okay. All right, and so I will be in the electronic case file. So that file that you all accessed to upload your exhibits for today, for today's hearing, that's where a copy of the order will be. If you would like to review it and grab copies of those. All right. So thank you all. Thank you, Ms. Cruz, as well, for being here today. And you're all excused and allowed to log off.
Thank you, Your Honor.